Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps our channel grow. For today's case, we are dealing with what happens when someone paints Black Lives Matter on a public street. Do other people have the right to paint messages on streets as well? This is coming out of New York in the case of Women for America First versus Bill Blasio. In this case, a group of women wanted to paint a pro-woman message on the street, and they asked for permission, and they were denied. And so the court has to analyze what the law is regarding this, whether this is a public forum, whether the government opened it to other speech, or if it's governmental speech. Let's get started with this. On July the 14th of 2020, Brooklyn-based artists painted a mural stating Black Lives Matter on Fulton Street in Brooklyn, New York. Here is an image of the mural. That definitely is a very big mural. The artist painted this mural without governmental knowledge, consent, or participation. The Office of New York City Mayor, Bill Blasio, learned of the mural on June the 15th and on the same day tweeted, "Just in, Fulton Street in Brooklyn will share the message that Black Lives Matter all summer long. We're making this block pedestrian only and working with authorities to coordinate the nearby transit." On June the 19th of 2020, the Black Lives Matter organization and members of the community painted a second Black Lives Matter mural on Richmond Street Terrace in Staten Island. The same day, the mayor's office tweeted, "We'll paint a Black Lives Matter mural in every borough," and embedded a tweet from the mayor saying, "We're not just painting the words Black Lives Matter on the streets across all 5 boroughs, we're sending a message that these are our values in New York." And 6 additional Black Lives Matter were then painted in various locations. So some people painted an unauthorized message on the street, and the government said, "This is great." And then they painted another one, said, "This is great, we want more." And so, yeah, that could be a thing. So, all right, let's figure out how that relates to the law. Defendants have reiterated the government's interest in affirming the values of Black lives. In responding to media questions about the murals, Mayor de Blasio stated that the Black Lives Matter movement transcends any notion of politics, and this is about something much bigger than any one group. Responding to questions about whether the mayor would approve a request to paint a Black Lives Matter mural, a spokeswoman for the city spoke about the importance of Black Lives Matter, stating, "For all lives that matter, we must make it clear that Black lives matter." Mayor de Blasio also distinguished between the Blue Lives Matter request and these murals, stating, "The original sin of the United States of America, slavery, and all the effects over 400 years, being brought out in the open in a new way, and chance for this country to get it right, to address the problem, to move forward, and summarized in 3 words, Black Lives Matter." So it's about something much bigger than any one group. It's about fighting a wrong, righting a wrong, and moving us all forward. Okay. On July the 9th of 2020, plaintiffs submitted an email request to Mayor de Blasio to paint a mural stating, "Engaging, inspiring, and empowering women to make a difference." The DOT stated that it does not permit installations on city roadways that are open to traffic. Okay, so now the women have gotten involved, and they'd like a mural too, with a much longer phrase, incidentally, and they want to paint it on a street, and the Department of Transportation says, "We don't allow installations on roadways that are open to traffic." Now, one will take note that the roadway was open to traffic before the mural was painted unauthorizedly, and rather than scrub it off and prosecute the people involved, they decided to close the street to make it pedestrian only. So, okay, so it's like, why can't you do that for us? Because we're not about your engaging, inspiring, and empowering women to make a difference message. We don't like that message as much. We're all about the Black Lives Matter message. Okay. The plaintiff has standing to bring a First Amendment claim and related requests for a preliminary injunction ordering defendants to permit the plaintiff to paint its own mural. The plaintiff does not have standing to seek a preliminary injunction prohibiting defendants from painting or maintaining any murals on New York City streets because the remedy would not address the alleged injury. Although the defendant does not dispute plaintiff's standing, the court has an independent obligation to assure that standing exists, regardless of whether it's challenged by any of the parties. To establish standing, the plaintiff must have suffered an injury in fact that is fairly traceable to the challenged conduct and that is likely to be redressable by a favorable judicial decision. To establish injury in fact, a plaintiff must show that he or she suffered an invasion of legally protected interests that is concrete and particularized and actual or imminent, not conjectural or hypothetical. The loss of First Amendment freedoms unquestionably constitutes irreparable injury. When deprivation of First Amendment rights is at issue, as it is here, the dominant, if not dispositive, factor in deciding a motion for an injunction is the likelihood of success on the merits. Here, plaintiff alleges violations of rights under the First Amendment, which is applicable to the states through the 14th Amendment, and prohibits the enactment of laws abridging the freedom of speech. Protections under the First Amendment are not absolute. Nothing in the Constitution requires the government freely to grant access to all who wish to exercise their rights of free speech on every type of government property without regard to the nature of the property or the disruption that might be caused by the speaker's activity. Speech restrictions imposed on persons on government-owned property, like New York City streets, are analyzed on a forum-based approach that divides property into categories including a traditional public fora, a designated public fora, and a non-public fora. The level of judicial scrutiny that must be applied to state actions inhibiting speech varies with the nature and the form in which speech occurs. So this is a classic thing. There are certain zones which are traditional public forum. Sidewalks for the purposes of speaking is a classic, and the park is the all-time classic, I guess. That's probably the exemplar is the park, where you can go to give your speech and stand on the soapbox and stand on the side of the street and give your speech. That's like the dominant thing. So whether that's a traditional public forum, whether it's some kind of limited forum, or whether it's a non-public forum. There might be many examples that are non-public forums, but, the question is, which category does this fall into? For reasons outlined below, plaintiff has not demonstrated a clear or substantial likelihood of success. The surfaces of streets are non-public forum to which the government may apply reasonably viewpoint-neutral restrictions. Plaintiff argues that public streets are public fora that have been immemorially held in trust for use by the public and time out of mind have been used for purposes of assembly, communicating through citizens, and distributing public questions. This argument, however, is unavailing. Plaintiffs do not seek to congregate and share messages with the public on the street. Plaintiffs seek to paint a message on the street. Okay, so there's a difference between assembling and painting on the street. Okay. The United States Supreme Court characterization of public streets as a place of assembly where citizens can communicate is undeniably distinct from an endorsement of the use of the face of the street, usually reserved for transportation-related guidance, as a message board for private speech. But not this private speech for some reason. The women's thing, not so much. The Black Lives Matter thing, then yes. Don't know why, but okay. As an alternative argument, plaintiff contends that by permitting the murals, defendants opened New York City streets as a designated public fora and triggered an obligation to permit similar expressions of different viewpoints absent a compelling reason for denial. A designated public forum exists where government property that has not been traditionally regarded as a public forum is intentionally opened for that purpose. So these were private messages that were pasted there. They're pasted without the permission of the government, and the government allowed them, which seems pretty intentional. Okay. The government, however, does not create a public forum or any variety by inaction or permitting limited disclosure. In addition, the government does not create a public forum where it engages in governmental speech. Yeah, but this was private speech, and then you kind of endorsed it afterwards. All right. Plaintiff has not shown a substantial likelihood of success with respect to this alternative argument, because plaintiffs have not shown the mural constitutes a private, not governmental speech. How's that possible? When they were painted, they were definitely private. And the government said, we like that message, so now it's governmental speech? I don't know. The government is free to select the views it wants to express. In doing so, it does not trigger an obligation to permit other speakers. All right. The freedom afforded to the government does not, however, mean it can simply affix a government seal of approval to pass off private speech as governmental speech, which seems suspiciously like what happened here. They did fix the government seal and attempt to transform private speech into government speech. Okay. To avoid situations in which the government could silence or muffle the expression of disfavored viewpoints, the Supreme Court has exercised great caution before extending this government speech precedent, which apparently we're going to do here for some reason. All right. Even privately contributed monuments can constitute government speech. Just as government commissioned and government financed monuments speak for the government, so do privately financed and donated monuments that the government accepts and displays to the public on government land. For example, the Supreme Court has found that monuments placed in a public park constitute government speech even though many of the monuments were not designed or built by the city and were donated in complete form by private entities. The Supreme Court rejected the premise that a completed work conveys one message, that of the creator or donor, and the government must accept that message to engage in the speech. Several of the factors the Supreme Court has looked into apply here. First, markings on public streets have historically been used as a means for the government to communicate with the public. Particularly in light of the local law, the surfaces of the street are reserved for governmental communication. Yeah, but the nature of the communication that's written on the streets is very different than the nature of the communication that's here. The communication that's written on the streets are things like line markings and turn arrows, and sometimes words like one way or bike lane or bus lane or something like that. But yeah, the writing on the road is normally more functional in nature. So yeah, it is used to communicate, but it's usually used to communicate things that will help the driver drive, not things that will distract the driver. So I don't really think that pointing to the fact that the streets are traditionally used by the government to communicate messages is really quite on point, because these messages are a lot different than the ones that they usually communicate when they're writing on the wall, writing on the street. Yeah. The pleading suggests this is not an instance in which defendants have merely affixed a seal of approval to pass off private speech as government speech. Really? Really? Because that seems suspiciously like exactly what happened. The defendants didn't merely affix a seal of approval to pass off private speech as governmental speech? Really? Seems suspiciously exactly what they did. Although defendants did not create a commission for the murals, the acceptance and preservation of those murals, in combination with the tweets, intention to share the matter that Black Lives Matter, suggests defendants use these privately donated works to engage in governmental speech. I'm not really buying that personally, no. Plaintiffs also contend that defendants' conduct is an affront to the First Amendment because Black Lives Matter is political. Whether the Black Lives Matter message has political content is not relevant to the question of whether murals constitute governmental speech. The fact that an elected official, such as a mayor, might seek to communicate a message that's appealing to voters suggests the free speech clause is serving one of intended purposes. If it was the government's idea in the first instance, maybe, but this is just purely private conduct. And how are you going to discriminate against some messages and not others? So if I go and paint a mural and you take down mine and not theirs, how is that not lack of equal protection? This reasoning doesn't quite work for me. Because the murals are government and not private speech, and therefore did not open up the surfaces of streets as a designated public fora, strict scrutiny does not apply to the denial of the request to paint their own mural. Plaintiff has also proposed, as an alternative to permitting plaintiff's mural, that the court grant an injunction enjoining defendants from painting or maintaining any mural. So it's like, why not silence all the speakers equally? That'd be equal protection. However, as noted above, plaintiff lacks standing to pursue this relief, as it would not redress the harm that's alleged here. Specifically, an injunction prohibiting all murals would not remedy the denial of a request to paint a mural. Well, it's what we call leveling down. When you have an equal protection problem, you can either level up or level down. The courts talk about this all the time. So you can either bring everyone up to the same standard or bring everyone down to the same standard, because everyone is equal either way. So if your complaint is, I'm not getting equal protection because I'm not getting what they're getting, we can either give you what they're getting or make sure they're getting only as much as you are. Either way, it's equal. So yeah, this would be leveling down, which is a normal remedy in equal protection. So I don't know why that's a problem here. It's not like a foreign concept. It would address the harm. It would make equal protection under law. An injunction prohibiting all murals would not remedy to request to paint a mural, saying engaging, inspiring, and empowering women to make a difference. Yeah, but it would make everyone equal. So there's that. Even if such an injunction would remedy the harm, it is not in the public interest. Interference with the government's ability to paint or preserve any mural on the street could pose serious, potentially unwarranted limitations on the ability to communicate with the public. Really? I mean, the government has plenty of methods of communication, and this is not a traditional one for this kind of communication. So I don't, and also it wasn't government commissioned in the first instance. It's just they're slapping a label on it because they like certain kinds of private speech and not others. So this feels a little bit nebulous to my legal thinking, but maybe that's just me. So that brings us to the end of the case of Women for America First versus Bill Blasio, the mayor of New York. In this case, a group of women wanted to paint a mural on the streets of New York saying that women are awesome. after a private person painted a mural saying Black Lives Matter, and the city tried to pretend it was their idea the whole time, which, no. And this court looks at this and is like, yeah, this is totally fine. I'm less sold. I do appreciate the idea that there can be such a thing as governmental speech, but this was private speech, and I think they did just merely put a label of acceptance on it, And the fact that speech of this kind is not normally on the streets makes it some kind of forum. So I don't really buy this analysis. I mean, this is from a district court rather than from a court of appeals, so I don't really expect it to be reversed on appeal, but who knows? And there are other murals like this in other places and other circuits, so maybe there will be a circuit split. But I'm not 100% sold on this reasoning because it seemed a little thin to my mind. But at least for the moment, that brings us to the end of the coverage of this case.